All right, seeing it's 1:30, we're going to get started here. Welcome. My name is Eric Hauge. I'm the Executive Director of Homeline, and you're joining us today on May 7th at 1:30 for our third Minnesota Landlord-Tenant Law during the pandemic webinar. Just a reminder, what's Homeline? Homeline is a statewide tenant advocacy organization. Our main program is a tenant hotline that any renter in the state can call and get legal advice in up to 4 languages: English, Spanish, Somali, and Hmong. And our staff is comprised of housing attorneys, tenant advocates, organizers, and others. So today we are again going to follow the format that we did last week. And if you're, just as a refresher for anybody who's been on previous calls, previous webinars, or any newcomers, a few weeks ago on our first one, we did an overview of major issues that we've been hearing about during the pandemic within tenant landlord law. And then we took questions. Last week, we mainly took questions. And again, this week, we have it set up so that folks have submitted questions in advance. And then throughout the webinar, you are welcome to submit your question via the Q&A tool, or you can raise your hand and we will call on you via audio as well. Recordings of all of the webinars are available on our website. We'll send out follow-up information. I'll also put a link in the chat in just a minute here. So with that, I am going to hand it over to Homeline's Managing Attorney, Mike Fra.
Thanks, Eric. Thank you all for joining us again today, and hopefully this will be another hour of answering your questions. Today's presentation is May 7th, Thursday, and we are talking to landlords / property managers, people who identify themselves in that vein. Some of you work for places like housing authorities, some are private landlords, some own 1 rental unit, some own hundreds, if not thousands of rental units. And I recognize some of the names on the list, and glad to see that you're tuning in to stay as informed as you can. A quick sort of, not recap, but just restate the key issues that our office is dealing with on a regular basis. The first one, and the most important one in landlord-tenant law, is the governor's moratorium on evictions. This sunsets or expires on May 13th, which is a week from yesterday, so next Wednesday. The governor has the power to extend that moratorium on evictions another 30 days. The House and the Senate could, if they decide to, intervene. Both houses of the Minnesota legislature would have to decide to end the peacetime emergency, which is the declaration the governor has made, which is tied in time to the eviction moratorium. But we don't know what will happen next week. I know that next week on Thursday, we'll be having a different tone, because we'll either be talking about the fact that that moratorium was extended or that it was removed, and then what that will mean going forward for landlords and tenants. But as it stands right now, a landlord is not allowed meaningfully to file evictions. They could for a tenant seriously endangering others, or for violation of the specific state law that talks about no drugs being in the rental unit, no illegal drugs, no illegal weapons, no prostitution or stolen property. It's a very narrow grouping of violations that a landlord can file an eviction for today, again, May 7th of 2020. Also, landlords are not allowed to terminate a tenancy, which is not defined much more than that in the governor's order. So if a landlord had given a notice to vacate for a tenant to vacate by the end of April, and the tenant was still there May 1st, the normal remedy a landlord would have would be to go file an eviction for what we call holding over. That would not work now. The landlord couldn't file that eviction on May 1st for holding over. And so the question will be, what happens if a landlord gives a notice to vacate, or has given a notice to vacate for the end of May, and on June 1st, the tenant is still there, but the governor's moratorium is still in place? I think we'd be giving the same explanation right now that we would be then, which is that that notice would be invalidated. The other two notable things that we deal with repeatedly right now are rent increases. There is an anti-price gouging rule that the governor also put into an executive order, a separate executive order. And that price gouging rule covers a lot of different things, necessities basically, but housing is listed among them. And there is a 20% cap on how much service or a good can be raised price-wise during the peacetime emergency. And there's also an exception for if it's going well above the market rate. There's some vague language in there. The 20% rule is a fairly firm rule, but the market rate analysis is a little bit more complicated, obviously. There was a article in the Star Tribune today about the Attorney General's office enforcing some of the executive orders, especially in the housing realm. We have worked closely with the AG's office. We obviously get a lot of calls on our tenant hotline. We've taken over 1,100 calls from tenants on COVID-19 related issues on our free hotline, and have sent many folks to the Attorney General's office, and they send other people to us. They work on a certain number of types of cases, and we know which ones they are, so we send them over to them. But the Attorney General's office had reported that they'd had 400 complaints of landlords seemingly or threatening to violate the eviction moratorium or the termination of tenancy moratorium, usually resolved by the Attorney General's office contacting the landlord and saying, you can't do this right now. But there have been a few cases where they've actually enforced this. I'm not sure if they've enforced any of the price gouging violations. If a landlord violates the eviction moratorium, it's a standard misdemeanor. The eviction moratorium, it's a standard misdemeanor charge. So up to 90 days imprisonment, and I believe it's $1,000 is the penalty. The price gouging is different. That's a big penalty monetarily. It's up to $10,000 for each transaction. So it's one that I certainly wouldn't want to flirt with if I were in the landlord's shoes right now. Nor do we see a lot of rent increases happening. We do still see some, but we're also hearing of landlords actually lowering rents remarkably, which I've done this since 1996 and never seen the rents go in that direction. But we're not really sure. I think as an industry, the landlord-tenant industry, we're not really sure where the market is heading right now. Eventually, this eviction moratorium is going to be lifted. We don't know when. And when that happens, I'm not sure how many tenants will just leave. And when they do that, there might be empty apartments. And I think landlords are starting to sense that that's a possibility. The last thing that we're dealing with on a fairly regular basis is the question about when a landlord can enter a rental unit. We've been around since 1992. In fact, earlier this week, Homeline took its 250,000th caller representing a renter household. So 250,000 tenants have called our office since 1992 as of Monday. And we have kept track of why people call us since we began. We have about 75 different categories of issues that the tenant calls about. Privacy, or when the landlord can come in, has always been in the top 10, but it's like 8 or 9 or 10. Since COVID-19 started, it's in the top 2 or 3. Unsurprisingly, because people are afraid of having any contact with pretty much anybody. And so we have created, this isn't something we do often, but we actually created a position paper, which is I guess what we're calling it, on privacy, when a landlord is allowed to actually enter a rental unit. And I think Eric will probably, yep, he's put that up in the chat room as a link. You're welcome to look that over and see sort of this assessment, because it's a complicated issue in this new COVID era. And we tried to address it from that lens. With the COVID-19 concerns that everybody has, what should a landlord be doing? What's a tenant expecting? What should a tenant be doing? But anyhow, those are the things that we're seeing again and again. The eviction moratorium, again, is the giant shadow cast over the entire landlord-tenant industry in Minnesota right now. And whether that shadow moves next week or if it stays in place is the big question we're all waiting to see the answer for. That being said, I know we have close to probably 10 questions that had been sent in advance, and Eric is going to start with asking those, and then we'll get to our live questions today.
All right. Again, you can submit your questions via the Q&A system via Zoom. One of the questions submitted in advance. My current rental license is due to expire on May 31st. My renter's lease is also set to expire the same day. The tenant originally alluded that they would to the fact that they would not be renewing their lease. However, now inform me they will not be leaving. How does that work if we do not wish to renew our rental license, and instead wish to list the home for sale instead, or homestead the property? Would the renters need to vacate the premises if we no longer have a license, and how would that affect the current peacetime order?
Yeah, that's a complicated question. There's a lot of pieces in there that matter quite a bit. What I would start with in answering it is that we have the eviction moratorium. That, again, is sort of the dominant figure in landlord-tenant law right now, and that's the key question we have to answer is, could the landlord actually remove the tenant on June 1st if there's no rental license anymore and the landlord is given a notice to vacate? I don't think a landlord could sustain an eviction in court. I don't think it would be scheduled. I don't think it would be fileable under the governor's order right now, even for that reason. It's a different question than most of the ones that we get. Almost all of them are about non-payment of rent. The tenant hasn't paid their rent, so I want to file an eviction. How do I do that? Short answer is the landlord just can't right now, not really. But this is a different question because if the landlord doesn't have a rental license, there's an argument that it's not a legal rental at that point. And then so the landlord's new argument would be, hey, this is not technically complying with the city's rule on rental licensing. That's how most rental licensing is set up. It's set up through a city, not through a county or the state. So it's a different argument, but I think the same answer would come into play. If the tenant refuses to go on June 1, the landlord's only real options to remove the tenant, I guess they could call the police and say, hey, we don't have a rental license and we want them removed. The police are almost certain to say, this is a civil matter. You need to go file a case in civil court. And if they go try to file an eviction for, I guess it would be for holding over, would be the evictions, would be this probably the only thing that an eviction can be filed for based on what we have in front of us. I don't think the court would schedule the case based on what we have in front of us right now. Now, like many things happening in landlord-tenant law right now, we're basing our answers based on what we think a judge or a court probably should do. Lawyers rely almost exclusively when they give advice to people on precedents. What's happened in past cases that are similar to that case? Or what have we seen happen before when this sort of thing has come up? But the laws that we're talking about, these executive orders, are 6 weeks old. And we can't tell you how they're going to play out in eviction court because you can't really file evictions. So it's difficult to determine exactly what would happen in a case like this, but that would be my best guess. One thing I didn't mention at the outset, which I should have, is that in my line of work, landlord-tenant law, I almost always talk exclusively about state law. Sometimes there's some city rules. Mostly it's state law that we're talking about. At the federal level, though, there was something enacted in late March called the CARES Act, and it was a sweeping bit of legislation. You probably heard about many parts of it, but from a landlord perspective, why it matters is that landlords are barred from filing evictions in certain properties through effectively late August. July 25th is when the period of evictions being filed is technically over, but then the landlord has to give a 30-day notice after that. So August 25th or something like that is the earliest the landlord can have somebody out if the CARES Act is in play. So where does the CARES Act matter? First of all, it's only for non-payment of rent cases. Also, the CARES Act specifically bans late fees, which the governor's executive order does not ban late fees, although many landlords have been waiving late fees as the pandemic started and have continued to waive late fees. But under the CARES Act, the bigger question is which landlords are covered by the CARES Act. And so any federal subsidy that's involved, if the entire building is subsidized, then certainly the CARES Act kicks in. A nice umbrella sort of starting point is if the building is covered by the Violence Against Women's Act, VAWA, then it's covered by the CARES Act. A Section 8 voucher holder would certainly be covered by the CARES Act. And mortgages that are backed by Fannie Mae, Freddie Mac federally, insured mortgages. Now that's the really weird catch-all and difficult to determine who would be covered by that. We have seen Michigan and a few other states now that have issued orders from courts saying that if a landlord is to file an eviction once the eviction moratorium is lifted, that the landlord will have to affirm that they are not covered by the CARES Act. Probably in Minnesota, landlords file evictions under penalty of perjury. So a landlord has to be sure that they're not covered by the CARES Act. And the landlord is probably the only party that can actually figure this out too. They can go back to their mortgage provider and say, hey, where did my mortgage come from? Is it backed federally? Is there Fannie or is there Freddie? Is there any kind of federal backing involved here? And if there is, then the landlord can't file the eviction until late August and has to give a notice in late July saying that they can do that. Anyhow, I probably got off a little further than that question was looking for information for, but I thought I'd mention the CARES Act.
And in the chat, I linked to the specific section of the CARES Act that discusses it. And then there is this search tool that the National Low Income Housing Coalition has created that allows you to search some of the federal databases. But those are primarily multifamily properties that are subsidized. There's a large number of properties that you have to contact your mortgage lender to find out if you're covered. Next question submitted in advance. Can we tell someone we are not renewing their lease and have the lease to roll over to the month-to-month provisions in the lease?
Okay, so what I assume is going on here is that we've got a one-year contract that is ending, and the landlord would prefer to not go with another one-year contract and instead have the lease roll over month to month. If I'm generalizing, this is how most leases work in Minnesota anyway. If you have a one-year lease to start with, most leases roll over. If the tenant, let's say the lease ends May 31st and the tenant stays there past May 31st, they're there on June 1st, there's no conversation between the landlord and the tenant. They never talk about renewing or vacating, nothing is discussed. And the tenant is just there on June 1st, they pay the rent and the landlord accepts the rent. At that point, what's effectively happened through case law and some statutory application is that we have probably a month-to-month lease going forward. That's what it's going to be in almost every case. The terms of the original lease remain intact. So if there's a no pets clause, for instance, then that stays there. It's not like there's no lease. That old lease is still largely in effect. We've just got a new duration of the lease, which is a key component of a lease to be sure, but that is effectively considered by the courts and cases that it makes sense to make that a month-to-month lease. And so I think what the question is asking is, do I have to go to another one-year lease if my lease expires during the eviction moratorium? There's nothing in the governor's order that says that a landlord has to extend a lease for another year. I think it's going to be presumed by a court that a month-to-month lease is okay. I think the landlord and the tenant can certainly agree to a one-year lease, and many times landlords want a one-year lease because they want the certainty of having a tenant that's locked into a contract that's agreeing to pay a certain amount of rent for the full year. There's all kinds of reasons why landlords like longer-term leases. Some landlords prefer shorter-term leases. But I don't think that anything in the new COVID-19 executive orders or any proposed legislation that I've seen would mandate that a landlord renew for a year.
The next one appears to be more like a statement, but maybe you can talk about it. I have a tenant that was constantly late with their rent. They have decided not to move out and gave me 90 days notice without paying.
That's the whole question?
Yeah.
Okay. Well, so a tenant is allowed to go. I'll start by answering it that way. This actually wasn't especially clear from the governor's initial executive order on sheltering in place, which is different than the peacetime emergency order. In fact, they have different dates that line up, so it's a little confusing where all these dates line up. Again, the key date for landlords in Minnesota is that the eviction moratorium is officially, the current one is over May 13th, but the governor could extend that. But a tenant is allowed to move. A tenant is allowed to give a notice to vacate if they give the proper written notice to vacate to terminate their lease. They're either at the end of their 1-year lease, or it's a month-to-month lease, and they give a full rental period's notice. Tenant's allowed to do that, and they're allowed to move out. So a tenant is allowed to go. A landlord is not allowed to make them go. Is the real difference maker in the executive orders when it comes to what can a landlord do when forcing a tenant to go. Now, the tenant still owes this rent, I'm guessing. It sounds like they haven't paid for a couple of months and maybe 3 months. The landlord would have a claim against the tenant later on in a different court, conciliation court most likely, which is also effectively currently closed, which is true for tenants as well. That's where they sue landlords for security deposits. And one of the top 5 topics still that people call us about is trying to get a security deposit back. And we have to tell renters, sorry, you can't really file a suit for a security deposit right now. It's just not schedulable. Also true about rent escrows for tenants, which is where they try to force landlords to make repairs, not really fileable currently. But anyhow, the landlord would still have a claim against the tenant for the unpaid rent, like they always would. But the tenant is allowed to give a notice to vacate and to vacate.
Next question. How do I handle showing a property available for rent now while maintaining health safety within a condominium setting?
Yeah, and this is something that we mentioned early on, which is that landlords wanting to enter a rental unit for a variety of business reasons, how does that work in the COVID-19 era? And I'll just touch on the high points, and Eric, once again, has put in the chat box our position paper on privacy and when a landlord can enter right now during the COVID-19 era. So nothing in the law has changed officially on paper. The executive orders don't mention when a landlord is allowed to enter. I know that realtors have sort of adopted this unofficial kind of code or creed of how to do showings now. And my advice is if there is to be a showing, I assume that this is what this question is asking about, is if the landlord wants to do a showing, the tenant is moving out at the end of May or the end of June, and the landlord wants to show the property to a prospective new renter, can the landlord do the showing? And if it is agreed upon that the landlord's going to do a showing and the current tenant agrees to it right now, or the landlord just sort of decides to do it whether the tenant wants it or not, the current tenant wants it or not, I encourage landlords to require both their employees or their staff along with the prospective applicants to wear a mask, wear gloves when they enter that current tenant's rental unit. I tell the current tenant that they should turn on all the lights. They should open all the closet doors so there's fewer contact points, physical contact points, to minimize the contact that's necessary, just to make this as painless for everybody as possible. The much deeper question is, can a landlord unilaterally decide to come in right now? So again, the law hasn't changed. The old law on privacy says that a landlord can't come in unless they have a reasonable business purpose and they try to give reasonable notice. That's all the law really refers to. However, the law has a phrase in it which up until about 7 weeks ago didn't mean much. It said under the circumstances. So under the circumstances, what is reasonable business purposes? What is reasonable notice? Is it reasonable to insist on an in-person showing in a world where virtual showings are possible? In fact, for realtors, it's kind of the starting point for a lot of showings. So a lot of landlords are working with the current tenants and saying, hey, take some pictures. Here's what I want pictures of. If you could clean out that kitchen really good, then take a picture of it and maybe do a quick video. And then I'll post that online and then people can see the place without having to come in. This is especially problematic for current tenants that have heightened risk concerns. They're immunocompromised, or their kids are, or they're elderly. These people are calling us up and they are deathly afraid, for good reason, of anybody entering their home. And so the question becomes, can a tenant actually stop a landlord from coming in this situation? Can they barricade the door? Can they put the dresser in front of the door or not take the deadbolt off? It can be a really contentious issue. Again, let's say the tenant does that. If the police show up because the landlord calls the police and says, this is my property, I own it, let me in, police are very likely to say this is a civil matter. So then the ultimate remedy most landlords would have would be they could file an eviction against the tenant for, I guess, interfering with management or some phrase like that that is a catch-all that we see in many leases. But the landlord can't file an eviction right now for that reason. So it's kind of a messy new situation. I encourage all landlords and tenants to talk to each other about, is there a way to do this without having an in-person showing? And if the current tenant can help make that happen by, taking the high quality videos that phones seem to be capable of doing right now, or photos, then that'd be great. But until we actually see a court case on it, we're sort of stabbing around with the answer to that one.
Next question, resident notification. Do we need to inform tenants about confirmed cases in an apartment building?
Okay. So this question is asking, if there is a tenant with COVID-19, do I have to tell the other tenants in the building that that neighbor has contracted the virus? I don't know of any laws that require that. The closest analogy I can think of is when we have convicted sex offenders that move into neighborhoods, but this isn't the same thing at all. There's no specific law that says that a landlord must disclose that information to neighbors that I've seen anywhere so far.
I'm going to try to summarize this next question. It's a landlord who was not planning on evicting anyone in March, but now it's May, and I need to end their tenancy, not based on money. When are the courts going to open? I need to know when the state or the feds are going to bail out landlords. We are the only business that the president and governor told tenants not to pay. Also, there's going to be a bloodbath at the courts as soon as this order is lifted.
Holy cow.
What plans do the courts have to handle all these cases?
Okay, there's a lot there, and I want to address all these pieces. The first part was they wanted to get somebody out and they wanted to know when the eviction order would be lifted, right?
Right.
I think.
Yeah, I mean, it says they haven't paid, but then they're asking that they want to end the tenancy not based on money, but also asking when the courts are going to open. So
yeah, so the court's opening, and wow, I just realized how odd the tie looked. The court's opening, again, we are told that a landlord is allowed to file an eviction starting next Thursday, it would be, unless the governor renews or extends the peacetime emergency another month, which could happen. And the governor has the power to essentially unilaterally do that. We don't know if that will happen. We won't know until it actually happens. And so I can't tell you for sure when the courts are open. The other part, again, is the CARES Act. If there's a federally backed mortgage, or if it's a larger building that has a subsidy of some type, or there's a voucher, then yeah, a landlord can't file the eviction for non-payment until August, after having given a notice in late July about that. There was a couple statements there too. Give me a couple other pieces, just one at a time though, if you could.
when is the state or the feds going to bail out landlords?
When are the states or the feds going to bail out landlords? Well above my pay grade, by a level of 1,000 at least. I don't know. I think that some landlords were eligible to apply for some of the small business loans, although it's not my area of expertise. Our office has been trying to keep our knowledge of landlord-tenant laws specifically as absolutely up to the minute as possible. And trust me, that's not easy. Again, I've been doing this a long time. And in general, if laws change in landlord-tenant law, it takes years for them to change. Slow, deliberate processes, either at the city or at the state level, it takes years for those laws to change. This law changed pretty much overnight, and then it changed again, and then it changed again. There have been a lot of different rules that have come out in different arenas, and I don't know when the federal or state government will end up bailing out landlords. I will say this. We do a call-in or question and answer session every Wednesday at 1:30, where we talk to tenants and to social workers who work with tenants, people like that. And the question that we get on Wednesdays that we don't get on Thursdays is, when is there going to be a rent strike or a rent cancellation allowed by the government? When is the government going to say that rent just isn't due? And obviously we don't get that question on Thursdays because landlords wouldn't be in favor of that. The governor's order clearly says rent is due. It's a very plain sentence that rent is still due. So rent is due from tenants to landlords. If tenants don't have it, then they aren't paying it. In general, if tenants have the rent, they seem to be paying it. Seems to be what we're hearing. Last month, we heard somewhere between 10 and maybe a high of 30% of tenants didn't pay rent by the 5th, which is sort of what landlords use as a guide as to whether they're going to get paid or not that month. But by the end of the month, those numbers had gone down substantially from what we'd heard from landlords and from industry groups. May is predicted to be quite a bit worse. And if, let's say, this eviction moratorium extends into June, I'm sure it will be even worse. The $1,200 stimulus check that many people got is not coming again, as far as I know. Unemployment may or may not be stable. So I assume that this issue will get worse before it gets better from both the tenant and the landlord perspective, unfortunately. But rent is clearly, as I mentioned, due to be paid. Was there another piece of that question, or did we get all of it?
I think you answered the other thing that the governor has told tenants to pay, and then just the general, what plan do the courts have to handle all the eviction cases?
Yeah, that's actually, honestly, the court situation is going to get worse the longer the eviction moratorium goes on. If the moratorium is lifted next Wednesday, there's going to be a ton of evictions, of course. I don't know how many a ton means. Normally in Minnesota, there's 17 to 20,000 evictions per year. That's been pretty static for quite a while. I guess it could dip as low as 15,000 depending on how you look at it. But if the eviction moratorium were lifted next week, I would guess there's going to be tens of thousands of evictions filed. And if we wait until middle of June or the middle of July, it's going to be even more tens of thousands, maybe hundreds of thousands of evictions filed. I'm not sure how well the courts are going to be able to address that. I think it'll be more possible for the courts to process these cases quickly in the core counties, Hennepin and Ramsey County, where they have housing courts that are actually designed for nothing but housing cases. For those of you that have seen those cases, the eviction hearing calendars, they really resemble factories. There's a lot of stamping going on, and it's just a really efficient system where they try to get through a whole bunch of cases in a 2-hour block, 30, 40, 50, 70 cases in a 2-hour block. And if you just think about that, how much time are they spending on each case? It's not a lot. Now, a lot of those tenants don't show up because they don't have any defense. They don't have the money. Almost every eviction is for non-payment of rent. So there is that efficiency there, but I'm not sure that even the core counties are going to be able to manage to do these cases as efficiently. One of the things that we've heard is that counties that do have a lot of evictions historically are thinking about expanding the number of days that they're going to do evictions, which probably makes sense. These are going to be among the first things that are filed, but the entire court system is going to be inundated with people that have been waiting to file cases. It's not just evictions that courts deal with. There's family law cases and civil suits and criminal cases, and so the calendars are all going to be very full. I actually think that the courts that are going to struggle the most with the eviction flood, and I have no illusions about whether there's going to be a flood of evictions filed or not. There will be. The courts that are going to struggle the most are the ones that traditionally have not heard that many evictions, because they may not really understand the ins and outs of evictions. This isn't rocket science, but it's still complicated, and we're talking about, on the tenant side, their home, that's important, and on the landlord side, probably a sizable investment, so that's important. So we don't want judges racing through something that they don't understand. And in counties where they haven't traditionally had a lot of evictions, if they suddenly get 100 evictions in 1 week, to figure out how to cope with that is going to be incredibly difficult for both the judge and their staffs to try to do things as correctly as they can. And so we've got multiple concerns about the court system, just like landlords do when the court doors open up finally.
With the current order in place until 5/31, when can we send a notice to vacate, not an eviction? Can we do that now for the end of July?
Yeah, no, I understand the question, and it's a good question. It's a question that I actually got from a legal aid lawyer the other day from somewhere else in the state. There's only so many tenant attorneys in Minnesota that do nothing but landlord-tenant law, so we are fairly connected and we talk to each other quite a bit. But they were asking that same exact question, trying to understand exactly what the governor's order means. Because the governor's order says that a tenancy can't be terminated. That's what it says. I'm actually paraphrasing it, but that's pretty much what the sentence says. So that's an easy question to answer for a date that's already passed, right? So if you've given a notice to vacate for the end of April, and the tenant is still there May 1st, can you kick the tenant out, terminate the tenancy at that point? And the short answer is no, you can't. Not really. You can't go file the eviction. So it doesn't really work to do that. And that would be a violation of the governor's order because the peacetime emergency is still in effect. But at some point, the peacetime emergency will lapse. We don't know when, but at some point it will. And so if a landlord is given a notice to vacate or a non-renewal or a notice to quit, they're called all sorts of things, for a later date, and in this case, somebody's referencing July 31st, is that enforceable? So the landlord tells the tenant to leave by July 31st. August 1, the tenant is still there. Could a landlord go file an eviction for, again, what we call this is holding over? Well, the landlord can certainly file the eviction. They can always file the eviction. The question is whether they'd win that eviction or not. And a tenant defense might be, hey, you terminated my tenancy during the peacetime emergency, and I don't think that was legal. And we don't know the answer to that question. I think a very strict literal reading of the governor's order means that a landlord can't give a termination of the tenancy notice right now. But I know the Attorney General's office, to my knowledge, has not enforced that, I guess, theory that we have, along with other people that have that theory. So we won't really know until a judge hears that case. So I can't guarantee a landlord that if they give a non-renewal for some time after the peacetime emergency has lapsed, that it would be effective, is the short answer.
All right, those are all the advanced questions. So do you want to read them, or do you want me to live ones?
I'll let you pick. Go ahead.
Well, we had one that just came in that I think is pretty good. How would the covenants of habitability affect both landlord and tenant responsibilities regarding the virus? For example, would landlords be liable for not fully disinfecting an apartment for a new tenant? Does a tenant have a responsibility for letting a landlord know if they have the virus if they are leaving an apartment?
Okay. So would landlords be liable for not fully disinfecting an apartment for a new tenant? I guess maybe would be the short answer. So I'm trying to think of the nightmare scenario for a landlord here. New tenant moves in, and within a day or two, they contract the virus, and somehow it's provable that it can be traced back to that apartment that they just moved into. Would the tenant have a claim against the landlord for contracting the virus? I guess. I'm not sure. Tort claims in general against landlords are quite difficult for tenants to win. And this would be what we call a tort claim. So I'd probably bet against the tenant if this were the line of facts we had. And that's a pretty good set of facts for the tenant, argument-wise. You know, you can trace it back to the landlord, not disinfecting the place. I think the tenant could certainly try to force the landlord to de-COVID-19 it through a rent escrow process if a rent escrow is available. I guess they could do an ETRA, emergency tenant remedies action against the landlord if somehow there was a test where you could spray a chalk in the air and then you'd know that COVID-19 is present, so you could confirm there's COVID-19 present and the landlord hasn't resolved it. I guess a tenant could try to file an ETRA at that point, because ETRAs, emergency tenant remedies actions, are fileable for a very limited number of reasons. But that might be one of them that a judge would say is okay. The next part of that question, does a tenant have a responsibility for letting a landlord know they have the virus if they're leaving an apartment? I know of no laws that require a tenant to disclose that either. Maybe moral responsibility to do so, but legal responsibility? I guess the landlord could try to sue the outgoing tenant if they didn't tell the landlord about COVID-19. The next tenant contracted it, and that next tenant is suing the landlord. They try to blame the prior tenant for having it happen. There's an argument there, but I don't know of any specific laws that require that as well.
Tenant's lease up March 1st with a notice of non-renewal gave tenant option to remain on property until the end of May. If the tenant has not moved, what are the options? If a tenant verbally accepted to stay through the May 31st, could the landlord send a letter indicating that?
Well, I think a landlord can certainly send a letter saying, hey, you indicated that you were moving out. I'm accepting your notice to vacate, or something to that effect. The real question is what happens if they don't go on May 31st. And if the governor extends the eviction moratorium, the landlord won't have much for options at that point. They couldn't really file an eviction for holding over.
If a tenant brings up the option of mediation, who pays for it? For an example, for a non-payment, why would a landlord be motivated when they have the legal right to collect the money? Why would they want to pay extra for mediation?
Okay. So mediation is something that it's not just landlord-tenant world, but throughout the litigation world is an increasingly attractive option for a lot of people. First of all, evictions aren't free for landlords. Landlords, as many of you well know, cost a baseline $300 just to file, more or less. Plus serving some papers, you might have to pay somebody to do that, $75, $100. If you hire an attorney, then you're looking at $200, $300, $700 more on top of that. So evictions aren't free for landlords. Mediation might be a cheaper route than an eviction. And mediation isn't always something where somebody has to pay for it. Sometimes there's free mediation services available as well. So there's that. There's also the fact that most evictions are filed for non-payment of rent. And before a landlord files a non-payment of rent eviction, they should think about what it is they win if they win the case. If a landlord wins an eviction, they win possession. That's what they win. They don't win money, although sometimes tenants pay up as part of an eviction. They redeem. That's the legal word for it, redeem or redemption. But if the landlord actually truly wins the case, what they win is possession of the place. And in a lot of cases, that's not really what the landlord wants. They want the money. They want the rent. That's what their job is. Landlords are not in the eviction business. They're in the rent collection business. And so if there's a way to get the rent somehow without filing the eviction, maybe that's going to be a mediation where a payment plan is going to be drawn up, then it's something a lot of landlords do explore, whether it's through a formal mediation process or agency, or it's just the landlord talking to the tenant saying, hey, do you think you're going to be able to pay? So we talked earlier about the ensuing bloodbath that will happen when evictions are fileable again, whether it's May 14th or June 14th or July 14th or whenever it might be. I think there are going to be a lot of evictions filed. I think there will be. I don't think that there's any real argument about that. But I think, honestly, especially as this goes on, if a landlord has a tenant that isn't paying or isn't paying everything that they owe, from a financial perspective, I think they owe it to themselves and to their business to analyze what makes the most sense. Does it make the most sense to go file the eviction? And in some cases, it will. In some cases, that'll be the best financial move for the landlord to go file the eviction the day they're allowed to do it. But in other cases, I'm not sure that it is the best move for a landlord because, again, if the landlord wins the eviction, what they win is possession of the rental unit. And if they ever want to get paid back by that tenant who didn't pay rent during the COVID-19 epidemic, their odds of getting that money from the tenant if they get kicked out, if they get evicted, go down substantially. I mean, you can win. You could go file a court case in small claims court against the tenant for $2,000, $3,000, $5,000, up to $15,000 you can sue. You can send it over to a collection agency and try to wreck somebody's credit if they don't pay. Okay. You can do all those things, or both, or either one of them. But that doesn't mean the money gets into your pocket as a landlord. And I mean, landlords that have been in this game a long time understand that if you want to get paid by a tenant that owes you rent, once they leave, your odds of getting the money just aren't what they were. Again, sometimes it's a better move financially to cut your losses as a landlord. But if you've got a tenant who says, you know, when the COVID-19 epidemic is winding down, which we're all hoping for a million different reasons, but it's winding down and they've maybe gotten a job offer back from their old job, and it's going to be full-time and it's going to be the same salary, and they were out of work and they didn't have the income coming that they had before, but now they're stable again and they think they can get caught up if we just use $1,000 as the amount. Let's say that's the standard rent. And then the tenant says, look, I owe you $4,000. I get it. And I want to pay you back, but I can't pay you back if I'm paying for rent somewhere else. And you put an eviction on my record by filing the case. So here's my proposal. I'll pay your rent as it comes due going forward, $1,000. And every month I'm going to throw on another $500 on the 15th. So on the first I'll pay $1,000, on the 15th I'll pay $500. And it'll take me 8 months, but I can get caught up. All right, should a landlord take that mediated approach, that offer? Maybe, maybe not. Maybe they don't think it's a good idea. Maybe they think the tenant won't be good for it. But if they ever want to get paid back that $4,000 that they didn't get during the COVID-19, that's their chance to get it from the tenant. That's their best chance, I should say, to get it from the tenant. And it's worth considering. I mean, tenants are going to be in the same boat that a lot of other people are. And there's going to be tens of thousands of evictions filed, depending on when the eviction moratorium gets lifted in Minnesota. But I think that there's probably going to be millions, if not tens of millions, of bankruptcies filed in this country once the pandemic subsides. I don't, under the current systems that we have, I'd be shocked if that doesn't happen. And so a bankruptcy by that tenant might effectively wipe out what they owed to the landlord. So the landlord's odds of getting that money back become even lower. So I know I'm not exactly staying in the parameters of the question. It was just asking about mediation. Is that a good idea, more or less, and why should a landlord have to pay for it? But my point about all of this is I think every landlord owes it to their business as a landlord to think, is it in my best financial interest to actually evict somebody or not? And many times it will be. But there are going to be times when if a landlord looks at this and analyzes it, they're going to realize that it isn't. And I know, having talked to landlords already about this, that they're going to be doing this cost-benefit analysis. Is the eviction the right path for me to go in a non-payment case?
This question came in, I think, when you were talking about sorry, was I muted there?
I can hear you.
Okay,
yeah,
sorry. This question came in, I think, when you were talking about the AG's enforcement of the governor's eviction order. Just how do you violate the eviction clause? And I think what we've heard is the AG has gone after folks that are locking people out, shutting off utilities, but then also just giving threats of eviction notices to vacate, right?
Yeah, from what I understand from how the AG is operating right now, and first of all, they're taking this very seriously. They're spending a lot of time on the eviction enforcement. But I think what most of that time is explaining the rules to the landlord. So when you go to law school, one of the things they tell you and sort of drum into your mind is that ignorance of the law is no excuse. And in general, that's true. But the Attorney General's office, like everybody else right now, knows that rules are changing quickly. So I think in most cases, the Attorney General's office is calling landlords and saying, hey, what you're doing, well, normally you could do, you simply can't do right now. You need to back off. And most landlords are saying, oh, okay, I didn't know, or I didn't understand the rule. And that seems to be the end of it. I think if you get into the darker stuff where landlords are shutting off utilities multiple times, which we've heard of, or changing the locks or threatening to do that, then and not backing down, saying, I don't care that the Attorney General's office is calling me, then that's when the Attorney General's office is going to really have to flex.
Next question. Tenant is saying there's a water issue, repair issue or something, and they're saying they're getting sick from it. Landlord is responding right away to look at it. Maintenance needs the tenant to leave so that they can go in. Tenant refuses to leave. Are we protected that we have this in writing, or that they're refusing maintenance? We have other. This is not. So there's others that are doing the same. Other tenants. Saying the same thing.
Okay, so pre-COVID-19, there are sort of concepts around repairs. Like, for instance, if a tenant were to file a rent escrow, if they could right now, for that landlord not fixing this water issue that was brought up here. One of the defenses a landlord can have is that the tenant unreasonably denied access to the rental unit. And so I suppose that would be the landlord's argument here. I'm not built into this question is sort of this concept that the tenant has to go to have work done in the apartment, and I'm not sure where that's coming from. There's probably still a way to accomplish social distancing while the tenant is still in the rental unit. But many times it can be something as simple as, hey, look, we can't afford to eat if we have to leave for a full day. We get calls like this right now where the landlord wants to come in and they need the place for a full business day to do work. And the tenant is like, well, I can't make lunch for my kids. I don't have any money to cook, and I can't afford to go to a restaurant. And so something like a gift card to McDonald's so they can go through the drive-through and have a picnic in the park or eat in their car is enough to convince the tenant that they can go. And so it can be worked out, but if a tenant unreasonably denies access to the apartment to the landlord, that is a defense to not making repairs. Yeah.
I believe in the last webinar it was stated we can't give a notice to vacate right now during the eviction suspension. Tenant's lease is up at the end of May. Is the suggestion that we wait until the 13th of May to see if Walls lifts the order and then give a 30-day notice, or send a letter now stating that effective June 1, the lease will go month to month, rent is due on the 1st. Are we not allowed to charge late fees during this situation?
Okay, late fees are only banned with the CARES Act. So it only matters if the CARES Act covers your property. So again, we talked, and Eric had posted a link to the places that automatically qualify if there's a Section 8 voucher holder, or once again, if your mortgage is federally backed, like by Fannie Mae or Freddie Mac. But I think the core of this question is, what about a notice to vacate? Should we give it now where it sort of straddles the peacetime emergency ending? Is that a good idea to give a notice now, or should we wait? The only cautious advice I can give you, I mean, if I were a landlord lawyer, again, I'm a tenant lawyer and that's all I do. But if I were a landlord lawyer, I would say, if you really want to get somebody out, you don't want to have to give the notice again, I would just wait until the moratorium is lifted and then give the notice or the non-renewal notice at that point, effective for the end of June, if you're going to give it. It's a traditional month-to-month lease right now, and the moratorium is again lifted this week. If it's not lifted till next month, then you'd give it for the end of July. That would be the conservative, safe advice on when you could give that notice and have it be effective.
Property taxes due on May 15th are delayed because of COVID.
I don't know the answer to that. I'm sorry.
So there's I'm going to post in the chat. There is a Hennepin and Ramsey counties are moving to delay some, and so it depends on your county, I think. So you'd probably want to check with your county. But here, there's a Star Tribune article about Hennepin, what Hennepin Ramsey are doing. I just posted it in the chat. Next question: water bills have skyrocketed. Is there anything landlords can do about this?
Yeah, so tenants are home more right now. The toilet gets flushed more. They take, they clean up more. They do more dishes. So there's a higher water bill. And I assume that means that we're in the middle of a one-year lease and water was included in the contract. If the tenant's paying the water bill, I'm not sure how the landlord is affected by this. But if the landlord is supposed to pay the water bill and they were basing the rent price on sort of a utility projection from prior years, they're thinking this is unfair, I shouldn't have to shoulder the burden. I think a landlord's probably stuck in that spot. If they have a one-year lease and the water was included, it's not the tenant's fault that they're home, it's not the landlord's fault either, but to change the rent, which is what effectively would be happening, is if the landlord wanted to pass on that water bill to the tenant in the middle of the contract, probably can't be done, is the short answer there.
On the CARES Act, what if there is no current mortgage?
Oh, that's a good question. Don't think we've had that one before. I don't think the CARES Act applies, unless, of course, you're getting a Section 8 voucher, the tenant has a voucher or something like that, then the CARES Act would be kicked in. But if it's no federal subsidy involved, then I don't believe the CARES Act would matter once the mortgage is satisfied. It's not federally backed at that point.
On Homeline's webpage, we have a sample privacy form letter for tenants quoting the statute about reasonable notice. If the tenant reports damage or maintenance, I think we kind of answered this one already.
Okay.
Is it lawful for the landlord to send a letter to the tenant giving them notice under that same law and saying that it's reasonable business purpose so that we did? Yeah, I think you answered that, right?
Okay. I think so too. Yeah. We talked about the privacy quite a bit there and repairs.
Do we have any recourse if a tenant has allowed an unapproved guest to move in? If the lease says anyone over the age of 18 needs to apply or be approved before moving in. And this, for example, this tenant let somebody in before the suspension.
Yeah, so this would be, if we didn't have COVID-19 going on, the landlord would file an eviction probably for an unauthorized occupant, which after non-payment of rent is the most common reason landlords file evictions in Minnesota. But right now, a landlord could not file an eviction for this reason in Minnesota. The CARES Act does not apply in this situation. That's just non-payment of rent. So even if there was a federally backed mortgage or a Section 8 voucher or something like that, the CARES Act wouldn't protect the tenant from an eviction once the state eviction moratorium is lifted. However, the state moratorium would stop this unless you can somehow show that the tenant is endangering others by having the person there somehow.
Landlord filed and received a writ prior to the CARES Act going into effect, but the sheriff has yet to visit the property, so the resident is still living in the apartment. They refuse to pay rent or vacate. Is the resident covered under CARES even though the landlord has the writ? When would be the soonest the landlord can change locks on the apartment?
Yeah, I'm not sure about the CARES Act application to current writs. I read it, but it hasn't come up enough for us to really look into it because the state moratorium is so much more impactful today. Um, so I can't really answer that from a CARES Act perspective, I'm sorry, but at the state level, the writs simply aren't being enforced right now under the governor's executive order as well. So the writ, difficult to know what would happen. In theory, once a writ is obtained by a landlord, they are supposed to expire after 30 days. I'm not sure if they will expire after 30 days or not, because we've never gone through this before to see if the time tolling on that was suspended or not. Um, a landlord might have to file yet another eviction, or the court might have to issue another writ, which they may be willing to do.
Do landlords have the right to do weekly inspections? The renter had not disclosed an mice infestation until a mice issue until an infestation had occurred. Trying to address it as best as possible before getting a pest company. Since they neglected to report it, it would be their responsibility and come out of their deposit. In addition, the home was in bad shape. Can I do weekly inspections, or can they push back and say they don't want us in because of COVID? Yeah, and I covered it.
Yeah, so a weekly inspection, pretty exceptionally rare for landlords to do weekly inspections. Saying that the tenant is responsible for the mice because they didn't report it, that's going to be a pretty subjective question that a judge would try to analyze. I mean, if they saw one mouse and thought, well, that's not that big a deal, a judge might say that's not on the tenant. If they're, leaving the doors open all the time and sort of oblivious to mice coming in, they think they're fine, then sure, a landlord's going to have a claim against the tenant. But it's actually a pretty high standard. You have to show that the tenant either brought the mice in willfully, maliciously, or irresponsibly to hold the tenant responsible for that. Again, a landlord might say they're unreasonably denying access to the place, but insisting on weekly access right now just to inspect a place is, well, that's a tougher sell for a landlord if this is ever in front of a judge, just because of the era that we're in, where everybody's trying to minimize all the contact they can have.
Are you aware of other states reopening eviction filings yet? Is Minnesota in the same boat as others, or are we being more cautious?
You've been in more of these nationwide meetings than I have, Eric. Do you have any thoughts on that?
I'll put in the chat. Eviction Lab, Matthew Desmond's outfit,
Sure.
has a policy scorecard, state by state scorecard. I have not reviewed it in great detail, but I think Minnesota is among, there's some that are doing more, there's some that are doing significantly less. I think the other example that you brought up is there are also then, court systems in each state that are acting more focused on making sure CARES Act is addressed too, because every state is impacted by the CARES Act. So I'll put that link in just a moment here.
I wanted to jump over to a different question in the chat box. Somebody that said that we didn't answer the question from last week. The tenant won't call back to let us know what's happening. They haven't paid rent. They won't communicate. The tenant hasn't lost the job that I know of. Okay, so a tenant doesn't have to lose their job to be protected by the eviction moratorium. It just isn't required. It's an absolute blanket protection that a landlord can't really file an eviction for much of anything. I've seen some landlords say, we're not going to do a payment plan with you unless you can show that you've lost your job, or somehow you've had your hours cut back, or maybe you've contracted the virus so you can't work, or some sort of requirement like that. But that's not what the moratorium requires. So the tenant not contacting you or not proving that they've lost their job doesn't mean that they're not still protected under the eviction moratorium. Now, I think if the tenant wants to stay there long term, I know many tenants that are talking to landlords right now saying, hey, I can't pay the full rent. I can give you 400 out of the 1,000. That's as good as I can do. Can we work something out where I can set up a payment plan? And I think most landlords would prefer that kind of approach. But there's no affirmative step that a tenant has to take to be protected from the eviction moratorium. I just think it's much more likely that the landlord will pull the trigger right away on the eviction later on when they are eligible to file it.
If a landlord, we have a couple minutes here, but we have a couple questions, so we'll try to get to them. If a landlord allows a tenant to pay late rent over a matter of several months, might that create an exception to other renters who want the same option and ultimately work against the landlord?
I guess it's a possibility, but I'm not sure how much stock I'd put in that. I mean, if one tenant doesn't have to pay all their rent up front, are the other tenants going to say, hey, look, I've got some sort of fair housing claim that you shouldn't have made me pay all my rent up front? Yeah, I guess. I guess if the landlord only gives favorable deals to a certain protected class, like Caucasians, for instance, and then nobody else gets that favorable sort of payment plan, then there would be on its face a fair housing complaint that the tenants could file. In my view, landlords should try to have some sort of measurement system in place. If a tenant comes to you and says, I want to do a payment plan and I can give you $5 out of the 1,000 that I owe, that's a terrible deal for you and you shouldn't consider it. But if they say, I've got half of the rent, maybe that's a bright line cutoff that you could have where you're starting to act consistently with tenants throughout the whole process and treating everybody the same, which is what fair housing is really looking for, is our landlords treating people the same regardless of protected class status.
One last question. Any help for landlords for loss of rent coming from the government? Tenants moved out, didn't pay last month's rent. They're out of state now, so civil suit is not an option.
Yeah, I mean, you could still file a civil suit against somebody, and landlords do file civil suits against people that have left the state. I think collecting that money is much more difficult when they're out of state. It might not be worth the effort to do. A lot of landlords in that position would turn it over to a collection agency because it's a lot less effort on the part of the landlord. You don't end up getting as much money back because the collection agency takes a percentage of what they collect if they do collect. But credit has a long reach, no question about it, and it has such an important role in our world, or at least it used to. I'm not sure how much credit's going to matter after the pandemic, but it used to have a huge impact. And so a collection agency saying, hey, either pay up or else your credit will be affected, used to matter a lot to people, even if they'd moved out of state.
Nice work, Mike. You got all the questions.
That was a lot of questions. Thanks for the rapid fire help. Yes.
So we are at 2:32, so we're going to wrap up. Again, just thanks everybody for joining us. A reminder that I put a link again to our COVID page where there's links to some of the resources we talked about. We're trying to add to that, keep it updated as much as we can. And then there's also links to the previous recordings. And you will get an email within the next day or so with a link to today's recording as well.
And we'll absolutely be doing one of these next week. We'll do this as long as there remains interest. We still had over, 60 people that joined us today. And as long as people are still interested about this and the rules are so ever changing, we'll be happy to continue to offer this available free of charge.
And next Thursday is May 14th. So it'll be again on May 14th, Thursday, May 14th at 1:30. And that is obviously the day after the peacetime emergency ends, so we will be seeing some news within the next week about if that is extended. So we will take Q&A on that one, but if there's significant legal changes, we may kind of focus on that stuff. All right, thanks again, everybody. We'll wrap up. Goodbye.